neutral, efficient, accurate, and accountable manner, unquote. Excuse me. The Elections Act 2011 is amended from time to time, and the regulations thereunder are the legislation contemplated by Article 82. I've then referred to a number of recent amendments to that act. Of importance and relevant to these proceedings is sections 39, 40, and 40A, which anchor the use of technology in elections. And I've referred to the 3-judge bench decision in Nairobi High Court, Constitutional Petition 328 of 2017, National Super Alliance versus IEBC, and 2 others, a decision that I had the privilege of participating in. There are also new regulations in the Elections Act. An example is the Election Technology Regulations 2017, and there I've referred to Rule 17, which now mandates the IEBC to retain electronic data in safe custody for 3 years after conclusion of the polls. The KIEMS kits, which were deployed in the last election for electronic registration and identification of voters and transmission of results, are also relevant. And there, I've referred to details in my area ruling in this petition, dated the 30th of November 2017, and reported in the Kenya Law Report under the title of Henry Tiore Ndiema versus IEBC and others, 2017 EKLR. Prior to its amendment, Section 83 of the Elections Act provided as follows: no election shall be declared to be void by reason of non-compliance with any written law relating to that election if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in that written law, or that the non-compliance did not affect the result of the election. I am alive that the Act was amended after the conduct of the impugned election. That amendment is irrelevant to the present dispute, and I've referred at length to the recent decision in Jackton Raguma versus IEBC and 2 others. For the proposition that the amendments to the Elections Act after the impugned poll had no retroactive effect. I will thus, in this petition, apply the law as it existed on the date of the disputed election. Section 83 that I have read out is couched in negative language to emphasize the caveat placed on this court. There is innate a rebuttable presumption in favor of the respondent that the election was conducted properly and in accordance with the law. It is also implied by that provision that elections are not always perfect. And I've referred to a number of cases, including Stephen Kariuki versus George Kimondo and others. Consequently, not all malpractices will lead to nullification of the result. And I've referred at great length to the dissenting opinion of Joki SCJ in the presidential petition number 1, Raila Odinga and another versus IEBC of 2017 at the Supreme Court of Kenya. I've also referred to the old precedent in Morgan and others versus Simpson in 1974. The parties to this petition are bound by their pleadings, and I've referred to a number of cases on that subject. The formal responses to this petition by the first to that respondents join issues on all the allegations in this petition. The respondents have thus put the petitioner to strict proof. The legal burden of proof remains firmly upon the shoulders of the petitioner. The petitioner must lead cogent evidence to impeach the poll, the cardinal precept being that he who alleges must prove, and to the required standard of proof. And they have referred to Section 107 of the Evidence Act and the old case of Onalo versus Ludeki and another. I've also referred to the explanation, which I find to be succinct, by the Supreme Court in Raila Odinga and others versus IEBC in 2013, and I need not read out that paragraph. The Supreme Court's propositions, however, were not entirely novel. The court was merely restating a view long held by the High Court in election dispute settlement. And I've referred to the cases of Munyao versus Munuve and the case of Ole Lempaka versus Komen and others, where the learned judges stated that each paragraph of the petition alleging breach of law, rule, or regulation, or which complains of any malpractice, must be proved by evidence. I've also referred to Housebury's Laws of England, 4th edition, volume 15, paragraph 670, and the old 1911 decision in Hawkins versus Powell. An election petition must thus succeed or fail on its pleadings and evidence. What is meant by that? All that is meant by that honors property is that first, the petitioner must proffer adequate or quality or sufficient evidence. Secondly, that evidence must be of a persuasive quality. It is only then that the respondents are called to rebut it. In the end, the petitioner must show that upon the preponderance of the evidence, it inures in his favor. If he fails to rise to the occasion, the petition must be dismissed. Excuse me. I remain alive that the evidential burden, on the other hand, keeps shifting in the course of the trial. This was well captured by the Supreme Court in Raila Odinga and others versus IEBC, Supreme Court Petition 5 of 2013, where the learned judges delivered themselves as follows, and I quote, "The petitioner should be under obligation to discharge the initial burden of proof before the respondents are invited to bear the evidential burden," unquote. The standard of proof in election petitions is higher than a balance of probabilities in ordinary civil cases, but not beyond reasonable doubt as required in criminal cases. And I've referred to the cases of Bowe versus Eliufo, Raila Odinga versus IEBC, Molilo versus Musonye, Richard Amana versus IEBC, among others. Excuse me. In Kakuta, Mai Hamisi versus Paris, Tobiko, and others, Nairobi High Court Petition 5 of 2013, I had the following to say on that subject, and I quote, "The crux of the matter is whether all the grounds raised by the petitioner sufficiently challenge the integrity of the poll. The court has to weigh the impact of the alleged irregularities on the outcome of the election. In the context of a general election for 6 electoral offices, it would be impractical to demand all expect mathematical precision," unquote. I'll now return to this petition. A good starting point is the right of candidates to have agents at polling stations. Section 2 of the Elections Act defines agent in the following terms, and I quote, excuse me, "Agent means a person duly appointed by a political party or an independent candidate for the purposes of an election under this Act, or B, a referendum committee for the purposes of a referendum under this Act, and includes a counting agent and a tallying agent," unquote. The Elections General Regulations 2012, on the other hand, define agent, and I quote, "as a person appointed under Section 30 of the Act," unquote. I have then studied Section 30 of the Elections Act in detail. It provides that party candidates shall only be entitled to 1 agent per polling station appointed by the party. DW1 at paragraph 9 of her affidavit had deposed as follows, and I quote, Political parties were to appoint agents for all their candidates, but subsequently, candidates were allowed leeway by the IEBC to appoint their own agents. On cross-examination, like I pointed out earlier, she clarified that candidates were allowed to appoint agents through their party. The directives given by the IEBC Deputy County Returning Officer on the 30th of July 2017 and reaffirmed on the 4th of August 2017 that candidates sponsored by political parties would not be allowed to appoint their agents was thus fully backed by the law. My considered opinion on that matter is as follows: that the offer to party candidates by the IEBC to appoint their own agents or additional agents breached Section 30 of the Act. The offer was at its best gratuitous. Fundamentally, the petitioner was a Ford Kenya party candidate. He was not an independent candidate. He freely conceded that his party had agents across all polling stations. In addition, his own agents were given access into 23 polling stations. True, the petitioner was denied his personal preferences, but I find there was no transgression of the law. I agree that a number of Form 38As did not have the official IEBC stamp. I hold the opinion that the lack of an IEBC stamp on Form 38A is not fatal. For starters, there is no formal space set out in the form to place a stamp impression. Secondly, the IEBC stamp constitutes what the regulations refer to as non-strategic materials. Thirdly, there is no express requirement in the Act or regulations that the presiding officer must stamp Form 38A. This is unlike the case of a ballot paper that must be stamped. My position is reinforced by my recent decision only one day ago in Sami Keboi Kipkeu versus IEBC and two others, Eldoret High Court Election Petition 2 of 2017. It is also reinforced by the decision of the Court of Appeal in IEBC Lenanada versus Stephen Mutida Mule and three others, 2013 EKLR. There is then the matter of missing signatures by agents. The signatures by agents are not mandatory. Regulation 79, subregulation 6 and 7 provide that the absence of an agent or candidate at the time of announcing results does not invalidate it. Form 38A provides for signatures by agents or candidates if present. Aggrieved agents or candidates have the right to protest or refuse to sign the form. Doubt is removed completely because at the foot of that form there is a space intituled refusal to sign, if any. Again, there I've referred to the decision delivered by this court on the 27th of February 2018 of Sami Keboi Kipkeu versus IEBC and two others. The petitioner alleged that the Cabinet Secretary for Water and Irrigation carried out unlawful campaigns for the third respondent at Mount Elgon Lodge, Edebes Center, and at Trans Nzoia Primary School. The dates were 1st July 2017 to 8th of August 2017.